The that we have this year. So we have Mr. Brad Vaughn. He is counsel to Georgia's Lieutenant Governor. He's
Okay.
going to be our judicial coordinator this year. We also have on call with us today Benjamin McMichael and Elizabeth Mahoney, both of them working attorneys here in Atlanta. So we're so lucky to have them. Some really great experience
Okay.
and a wealth of information for you. I'm going to let Mr. Vaughn do his introduction, and then you guys will have the chance to ask some questions and hopefully have everything you need to prepare for judicial.
Well, good afternoon, everybody. It's nice to see some of your faces and more of your screens there, but I'll look forward to meeting everybody in a few weeks when we come here. As Christine said, my name is Brad Vaughn. I am the legislative director and legal counsel for Lieutenant Governor Burt Jones. I work in his Capitol office in Atlanta. Prior to coming here, I was a staff attorney for Justice Charlie Bethel on our state Supreme Court and witnessed a lot of good oral arguments and a whole lot of bad ones over the years. So I want to sort of start off by saying that is all of you will come to Atlanta much more prepared than many lawyers who come argue before their actual state Supreme Court for the arguments there, and you all will do a great job. The years that we have been doing this program, we are always extremely impressed with the students' creativity, with their eagerness and their preparation, and including some people who are doing it for the very first time. Some of the best oral arguments we have seen through the years are people who this is their first time standing up in any kind of moot court, mock trial, anything like that, and giving it their best. So we encourage everybody of all ages who are participating in this, do your best, enjoy yourself, enjoy working with your team. It is a wonderful experience, and I know you'll get a lot out of it as we go. I want to give you a little bit of an overview about how our process is going to work over the next few weeks and tell you a little bit about the way that needs to unfold. And then we'll also talk a little bit about some tips for being successful here. As we finish up tonight, you will actually get the case problem. We have written that. We've kind of gone over what that's going to look like. It's a fun case. We like to do cases that involve the school setting. We think that gives our students an opportunity to put themselves a little bit in the shoes of the parties and think about how those things might impact them if they were in those situations. So our case is going to involve actually some people who wanted to go to law school. And it turns out that a school decided that they didn't have enough men that go to their law school. So they implemented a policy that would give a little bit of a favorable count to young men who wanted to come and enroll there. Turns out that infuriates somebody who didn't get in, and she has a problem with that policy and decides to sue the law school about that. Well, while she was doing that, she also went along and had some things to say publicly about that while she was employed at a university, and she gets fired. So we want to have some exploration of all of those issues, particularly around the school setting. As I was saying to our group before we brought everybody else online, there's enough about that should make everybody mad, which is always a great recipe for a good oral argument. It gives you a chance to, like I said, put yourselves in the shoes of school administrators, put yourself in the shoes of an employer, put yourselves in the shoes of students on really maybe either side of that issue and how you think that might affect you. You'll get a case problem from us. This year, that case problem will really be in the form of the documents that actual lawyers work with. We have written up a decision from a lower court where the court explains all of the facts of the case in some detail. All of those are facts that basically everybody has agreed to. So there's no contested facts for the court to have to resolve. And then the court has made a ruling on that. Now, it's from a 3-judge panel of our sort of simulated court of appeals. 2 judges have agreed with each other, so that's the majority opinion. And then you have 1 judge on the panel who has dissented and laid out an alternate view of what he thinks the decision should have been. So you'll have that perspective, which we think should help you. The problem will also contain some cases that both sets of judges have used to reach their decision. We want you to rely only on those cases that are in the problem. You can do some outside research. You can do some other things to help you understand these legal issues. Anything involving employment discrimination, anything involving the First Amendment, issues like that can be very complicated. But what we want you to do both in your brief and in your oral argument in the competition is only use those cases that we mention in the problem itself. That'll give everybody a level playing field. That gives everybody a chance to know what to expect. And then our judges will be prepared to ask some questions about those cases. I mentioned a brief. You will, as you will when you come to the actual competition here and actually stand up and argue your cases. When you do the brief, you will select one side or the other. You will either be the petitioner, who is the person bringing the appeal. They're the person saying that the court or the judges previously have gotten something wrong. And they've outlined for you, hopefully, what those in the brief outline why the judges got it wrong. Or you can be the respondent. The respondent is the person who won below, and you'll be the one saying, look, the judge at a minimum got it right enough, and I should win, and the other person shouldn't win the case. And you'll use your time to explain why. When you do your brief, you'll select one or the other. What I would recommend, and the best advice you can give to any lawyer, is that we call them briefs for a reason. They are meant to be short. They are meant to be concise. The best thing you can do is not waste a lot of time explaining lots of things that are not really directly to your point. You need to pick your best points. You need to get to them quickly. You need to argue them directly. The best briefs cut right to the chase and get to exactly why the decision below was wrong, if you're the petitioner, or why the petitioner's arguments or the are wrong and that the decision of the court below is correct. So that's the basic structure. You'll do that again when we actually get here for the arguments. Each round, you'll argue potentially as the petitioner. You may also, in another round, argue as the respondent. And I think there is a goal of sort of balancing that out. You may argue one side or the other a little bit more, just depending on how the draw comes in. But you'll need to be prepared for each team to know both issues that are presented and both sides of both issues and go. The typical pattern for this, for those of you who've done this before, you're very familiar with it, is that on a team of two, one person will argue one issue, the other person will argue the other. When you get here, you will typically kind of divide your time relatively closely between you when you get up and give your argument. But that gives everybody a chance to get an equal share of time to get up there. It also lets you understand your argument best. If you're the person who's going to be arguing the First Amendment issue, you need to understand both sides of that. Learning how to argue it from both sides is the best way to do that. If you're the person who's going to argue the piece about the law school admissions policy, you need to understand that from both sides, and learning to argue it is the best way to learn that. So we do all of that for a reason. And it's to give you an opportunity to critique your own arguments and sharpen them as you think through what the other side would say if they were arguing this case against you. A few tips that I would give all of our lawyers, both in your writing and in your oral arguments before the panel, first and foremost, is that you are an advocate. It is easy for people to want to sit and sort of explain or talk about things in a very general, almost sort of academic sense. A lot of law students begin law school thinking that way, and your job is to argue and win. And so your first opportunity you get to start making why your client's case is better than the other case, you should do it. The brief is a great opportunity to do that. It puts you in the setting of advocating, of arguing why your side's case is stronger or why your client, frankly, may be more sympathetic in a given case. But that's the hat you need to put on right away, is that I'm an advocate. I'm here to stick up for my client. If I don't stick up for them, nobody else will. That's the mindset of an advocate. The other thing that I will say with that is that that does have its limits. Your first and foremost responsibility as a lawyer is to be an officer of the court. You should be respectful of the court. You will typically, in our early rounds, be with a panel of at least two judges most of the time. It may be more, just depending on which room you're assigned to. But you'll typically be with a panel. You'll have more than one person. When one of the judges begins to speak, you should stop speaking. They're typically trying to articulate a thought, or they're beginning to form a question. You need to listen very carefully when that happens, because they're giving you a clue a little bit as to either what they think about something or something that they're not clear about that they want you to explore. I would also tell you with that to welcome questions from the judges. That is the best opportunity as an advocate that you have to really show off your skills. The people in years past who have really been the strong advocates are the ones who take those questions and just knock them out of the park. Sometimes the people who early on show that they're really good at that may get a little bit harder questions as time goes. If you don't give the best response, don't worry about it. Get right back to what you were saying. If the judge tries to take you off course, answer their question respectfully, but try to get back to your argument when you can. And I will tell you, just from the experience of doing this from a few years, sometimes we will have people who freeze up a little bit or who maybe sputter out a little bit the first few times. Don't worry about that. Some of the best lawyers in our state do that from time to time. They're people who are paid to come to court to do that. Judges, for the most part, are sympathetic people, and the people who are our judges will be sympathetic, I'm sure. They'll try to help you get your thoughts together, to give you a moment to kind of gather yourself there and get right back on track. So those are the two sort of speaking to the court and thinking through the thing with the court pieces that I would share. The other part of that is what you're really trying to do with judges, if you were doing this in real life, is you're trying to help the judges solve a problem. In this circumstance, this is a case that has been appealed to our state Supreme Court. And our state Supreme Court does not have to take every case that comes to it. They are like the US Supreme Court, they get to decide whether it's a case that's worthy of their attention. So we've set up the problem in a way that they've issued an order saying we'd like to hear this case, but they're doing that because it's a novel legal issue. It's something that that court has never decided, or that another court that has binding authority over them has decided. So you're trying to work through something novel. That gives you a lot of leeway. You can be very creative. You can say things that are helpful to your client. You can try to minimize the arguments of the other side or facts in the record that are not helpful to you. But always be mindful of that you're trying to help the judges get to a good result, because it's an open question of law. That's the big difference between a moot court setting and maybe a mock trial setting. In a mock trial setting, you're trying to convince a jury of your peers either as to someone's guilt or the innocence. The jury is finding facts. They're having to say, well, you were here at midnight and you're the person that stole this thing, or you're the person that killed that person, or something like that if it's a criminal trial. Here, all of those facts have already been resolved, and the judges are trying to decide what the law really means as it relates to those facts. So you've got to put yourself in the mindset of an appellate advocate now as well, which is we're really arguing about what the law means, not so much about what the facts of this particular case are. All that stuff has already been decided. One other point that I would make too with this is you will have the opportunity during the oral argument to obviously witness the other side, the other team that you are arguing against. If you're the petitioner goes first. They will typically take most of their time, but maybe reserve a little bit of time for rebuttal. I would recommend doing that. It gives you an opportunity to respond to some of the points that the other side has made. But while you're sitting there, you need to be listening very carefully to how the argument is playing out with the other team, for a couple of reasons. One, you may learn something or think about something that you hadn't thought of before in doing that, and that'll help you as you go. The second piece is that the judges may ask some questions to the other side that are actually helpful to you. And if you've got a good answer to those, your rebuttal time can be an opportunity to do that. The respondents actually get a great advantage in a case like this, because they get to sit and listen for like 18 minutes to the other side, and then they can get up and do whatever they want with their time. During my time as a clerk for the Supreme Court, we had a number of people who really did not even prepare an argument for themselves. They just spent their time responding to things the other person had said. You don't need to do that here. You need to have your own arguments prepared, and that's the best way to approach this. But if you do get an opportunity, it is impressive to a judge that you were listening, that you articulated why either that person's argument was wrong or why there's something in the record that contradicts what they said. That is a really great way to build momentum for your own case and to get the judge to trust you, because it's just like any other sales pitch that anybody would make. Your first and foremost is, I want to trust what the person who is talking to me is telling me. I want to believe that I have confidence in them, that I have faith in what they're saying. And I think a really great way to build that up is to show that you're paying attention to everything that is happening in the courtroom while you're doing that. I would just caution everybody on this as we go. Be prepared. Know your record in detail. That is the lawyer's first responsibility when they come in. They need to know the facts of their case. In some cases, that may be very important. The judges may want to really dig down and explore some of those facts. So spend some time with your teammates going over those things, whatever process you want to use to learn them well. And I would take some time even before you come and just get up in front of each other and talk about your case. Maybe not in a formal way with questions and answers, but just spending some time thinking through, what is this case really about? What really happened here? What is my strongest argument, either as the petitioner or the respondent? I think you'll find that you can explore those things much better informally first, and then start putting the formalities of standing up at the lectern and presenting yourself and doing all those things. Sort of the formalities of court that I'll go over, we tend to have people begin their arguments, and this is how arguments before our state Supreme Court begin. A clerk will call the room to attention, we'll call the case, and then during that process, we typically will let each advocate stand up and tell the court their name. It gives us an opportunity, frankly, just to call you by your name if we have questions for you as we go. It also helps us with the scoring for the rounds to know who is who among the four people that are up there. But as you get up to begin, it is commonplace in our court and elsewhere for the person to begin by simply saying the following: "May it please the court, Your Honor, my name is Brad Vaughn. I represent the petitioner in this case," and explain who that person is, and then sort of give a brief outline of what you're going to talk about. I would not spend a lot of time doing this, but it gives everybody a chance to stand up frankly and get a few very inconsequential words out before you jump into your argument. It gives you a chance to kind of catch your breath and clear your throat. And it's also just respectful to the court. That is a longstanding tradition of appellate courts, that those words would be what are used to begin. As you conclude, you need not do anything all that formal. You can just say, "Your Honor, thank you for the time," or, "Your Honor, I see that my time has expired. If there are any other questions, I'd be happy to answer them." Something like that in a respectful tone is just a way to signal to the court that you're concluding your argument. That is really it for the fundamentals of how this all goes. There are tons and tons of recorded oral arguments out on the internet for you to look at if you ever want to do that. Both of our state Supreme Court live streams them when they are actually happening, but a lot of them are also archived. If this is something that you're interested in doing, that's all out there. I encourage you to find those things. There are also lots of, I'm sure, just out on Google and YouTube of people arguing in court. It's a great way to just see how lawyers who maybe been doing this for a while approach it, how they look and how they talk and how they approach questions and things like that. That's all sort of part of the theater of this a little bit, and you can think of it that way a little bit if you want to. There is a dramatic element to this that sometimes is very effective. You are not trying to persuade somebody of someone's guilt or innocence, so don't think about it that way. But you want to be somebody that the court wants to listen to. You don't want to get up and just deadpan for 20 minutes. And you definitely don't want to whisper. And you surely, definitely do not want to get up and read from your notes or read your brief to the court. You need to think about making eye contact. If there are 3 judges, be sure at some point during your time that you have acknowledged kind of each judge on the panel. Look around the room. Look for body language, the signals that they give when you say something and that person just rolls their eyes. That person may have some questions for you coming up. If they did that during the other person's argument, that may be the person who is most skeptical of that argument. Judges are people too. Their face can betray a whole lot about what they think or where their mind is going on that. So be mindful of those things. And if it serves your client's interest, take advantage of that. I have talked way longer than I intended to. I love this stuff. It's very fun. It's fun to watch. I look forward to all of you being here, but I certainly want to leave some time for questions. And certainly if Ben and Elizabeth have anything else they would like to add to that, I'd like to give them the time to do that as well. So thank you all.
I'm just going to tell them that you guys can either unmute yourselves if you have questions. You can put them in the chat. Either is fine. Mr. Vaughn gave you a lot of great advice here. It's so fun. If I could have done anything other than going to education and the kind of the path that I would have gone on, it would have been law, and it would have been constitutional law. It's fascinating to me. You're definitely speaking my language for sure. We'll see if any of them are popping any questions in the chat. It might take them a minute to type it.
Yeah, it's...
Chloe, if you are a justice, you will be reached out to by me sometime in the next week or so. You will come the evening before around 6 or 7 p.m. I haven't finalized that time yet. But we will do some training the night before, probably with, I think Ben is not going to be there yet, but I do think Lizzie will be there and will be helping out. So you'll probably be with Lizzie that night. It looks like that was two of our justices wanted to know about that. Yeah, I need to contact y'all. Another thing to put on my post-it notes. Eva Mayfield, Mr. Vaughn, is asking if they need to, what should they know about the rules of court, like for objections or anything like that? Or are there any that they can use?
So the big thing there, again, objections are what happened during trials. We are past, at this point in our fictional world where we are in front of the Georgia Supreme Court, we are past any kind of objection stage. The rules are really, as formal as it seems, appellate court is actually a very informal setting. There are not real strict rules about what arguments you can make. You're not going to be asking questions of a witness or doing anything like what you would do in mock trial. So there's not really objections to be made. whoever is the chief judge of the panel, when they sort of decide that informally, will keep time. They'll give you some notification of when you're getting close. We usually try to let you know maybe at 5 minutes or 2 or 3 or something like that. It's very informal, however each judge wants to do it. But other than that, there really are not a lot of rules. The only real rule is the one that I specified earlier. You need to stick to the law that was in the actual opinion and don't go beyond that. You're going to be making arguments from that, and you're going to be using those cases to form a legal argument. But in terms of citing other cases or other precedents, we'd like you to stick to just what's in those, so that puts everybody on notice what is sort of out there to go. I see a related case. You said that or a related question, will there be written information on the court cases available? Yes. I'm actually going to give everybody, I think in the materials, a link to each of the opinions so that you can see them. They are all either state or federal appellate decisions. Some of them are long, but you'll be able to work through them, and it's helpful to you, I think, in some cases, to see the entirety of what the court decided there. So in addition to sort of what you would normally see, the legal citation for those, they're all cases that are available in the public domain where we will have access to it, and a hyperlink in the document will be available for that.
If you guys are done with your questions and you feel like you've got all the information you need, you are free to hop off. Again, if you still have questions, you can pull up you can unmute yourself, or you can put it in the chat, whatever you want to do. Otherwise, we will see you at Judicial. What's up, Ben?
Can I actually ask a quick question that I might have missed earlier? Is there a deadline for when the briefs are due to be submitted?
Mr. Vaughn, I'm going to defer to you on that one.
Let's see. We hadn't been. I'm glad you asked, because I had not actually.
I just thought about it.
Why don't we?
It
Why
will
don't
come
we?
to me later.
Yeah. Why don't we get them? If it works for everybody, and we'll do this informally, and then we can put this out in more formally. Why don't we get them a week in advance of the competition? That'll give us plenty of time to go through them, and so that everybody knows. A small group of us review those briefs. There's an award for the best brief, and we try to go through them and give our best consideration to those. That should give us enough time to get through that and communicate our decision to the conference.
Perfect.
Thank you, Ben. I had not thought of that at all.
The case information, Ava. So what we'll do is, after we get off this meeting, Mr. Bond and I will confirm the final case details. And then 2 things: we will probably send it out to advisors, but then we will also post it on the website under the conference documents. So the same place that you go to see, like, the bill book and the rules and all of that stuff, it will be somewhere under there. Like we're not getting any other questions, so I guess we'll let Mr. Vaughn go. I know he's had a long day travel, and we'll probably want to get some some rest. So everybody be on the lookout, or at least have your advisors on the lookout for an email, probably coming from me, with the case itself and just a brief overview of your expectations. The brief will be due a week before the conference, so whatever that Saturday is before that. I believe it's the 27th, if memory serves me right. October 27th. So sometime around then, I will formalize that and put it in the email when we send the case out. We'll also post it when we post the case details on the website. We'll put on there what the date is for those judicial briefs to be turned in. Bye, Tammy. Turn this recording off if I can remember how. Here we go.